My face is not going to go out in the paper. There wasn't any DUI.
Are enough indicators to request that evidentiary test, which you know as the state's attorney?
Well, do you know that discretion is allowed? We've been working really hard with law enforcement to build a good relationship, and knock that really down. My office is going to suffer now.
Eva Vekos, the elected Addison County State's Attorney in Vermont, was arrested for DUI on January 25, 2024. She drove her Volkswagen Golf to a homicide investigation where Vermont State Police troopers reported smelling alcohol in her breath.
Keep slowing your words a little bit, and then a strong smell of alcohol coming from the breath.
She refused a standard field sobriety test and a preliminary breath test at the scene, so she was arrested and transported to the New Haven barracks and processed. She was not at all cooperative at the police station either.
So they sent you because you're from Rutland in a different county?
Yep.
Well, who made that decision?
I don't know. It's above my pay grade.
There was alcohol in the breath and alleged slurred speech.
Are enough indicators to request that evidentiary test? Well,
Ryan doesn't know how to apply discretion.
Ma'am,
he didn't go to his.
I'm not gonna argue with you about it. To answer questions, may stop the question at any time. Do you understand each of these rights I've explained to you?
You can go ahead and read them. I'm not answering anything. Even if it seems silly, I'm just.
So you don't understand the rights?
I'm not answering any questions. I'm not making any comments. Go ahead and read all you want.
Okay. Do you want to talk to me now?
No.
You just heard her pull rank. She did it at the scene, asking if she could just call a friend for a ride home, and she just did it again.
So I'm looking for someone to pick. Yeah.
On December 16, 2025, Vekos appeared in the Vermont courtroom to enter a plea.
What is your plea to the charge of driving under the influence of alcohol?
No contest.
She received the same deferred adjudication as punishment every other first-time DUI offender gets in Vermont, though her actions the night she was caught continue to follow her today. Vermont Governor Phil Scott called for her resignation, and John Alexander, disciplinary counsel for the Vermont Bar, filed a petition with the High Court this month, seeking the immediate suspension of Vekos' law license. The hearing was held Thursday. This is that hearing. Let's roll, nerds.
Good afternoon. John Alexander, disciplinary counsel representing the petitioner, Office of Disciplinary Counsel.
Thank you.
Thank you. May it please the court. The question presented by the petition for interim suspension before the court is whether the December 2025 misdemeanor criminal conviction of the respondent, State's Attorney Eva Vekos, for driving under the influence, first offense, is in violation of 23 VSA 1201A2, constitutes a quote-unquote serious crime as defined under Rule 21 of the court's administrative order. It is our contention that respondent's DUI conviction does constitute a serious crime as that term is defined under Rule 21, because the state's attorney's criminal conduct, in light of the circumstances surrounding its commission, reflects adversely on respondent's fitness to practice law as a criminal prosecutor in respects other than her honesty or trustworthiness. Specifically, respondent's pattern of criminal and other professional misconduct on the night of January 25th, 2024 reflects adversely on her respect for her legal obligations, which is a characteristic just as relevant and essential to an attorney's fitness to practice law as honesty or trustworthiness.
Well, she wasn't charged with a felony, right? There's no felony here.
That is correct, Chief Justice. She was charged with and convicted of a misdemeanor, that is driving under the influence first offense. And the petition certainly does not contend that any first-time misdemeanor criminal offense reflects adversely on fitness to practice law. Rather, the nature of this misdemeanor criminal offense, and perhaps just as importantly, the surrounding circumstances, the aggravating circumstances of its commission and the aftermath, indicate that State's Attorney Vekos is indifferent to her legal obligations and lacks the characteristics needed for law practice, specifically as a criminal prosecutor.
Counsel, how far out is the net that you're casting? Because it's alleged that there were certain statements made several days after the event. Are you intending to rely on those as part of your theory here that this is a serious crime?
I believe what the justice alludes to is State's Attorney Vekos's email correspondence, I think about a week after the night of her arrest, in which she indicated to law enforcement leaders in Addison County that she did not feel safe around law enforcement and therefore would not be meeting in person with them, would not be doing scheduled trainings. And so I offered that factual circumstance as really corroborative proof for the validity of what I contend was a very thinly veiled threat made on the night of her arrest in the processing room of the New Haven barracks to Sergeant Neary, in which she indicated that this by which she meant her arrest and imminent citation for DUI, was going to damage her office's relationship with local law enforcement, and that her office being the Addison County State's Attorney's Office. And so to more directly address the justice's question, I'm not casting a wide net. I'm not trying to look at alleged conduct that has no relation at all to the criminal conviction. What the authorities seem to indicate, both within Vermont and outside of Vermont, is that for certain criminal offenses, it is not sufficient to consider the criminal conviction in the abstract or in a factual vacuum. Rather, for certain criminal offenses that may or may not adversely affect on fitness to practice law, the tribunal must look to the surrounding circumstances. And it's our contention that one of the most important surrounding circumstances is how State's Attorney Vekos reacted on the night of her arrest in her interactions with law enforcement personnel. It's quite apparent that State's Attorney Vekos was making a plea for leniency, but linking that plea for leniency to her status and position as the chief law enforcement officer of Addison County. And that in itself is an independent ethical violation. It's interference with, it's prejudice to the administration of justice.
Do you think that there is a different standard or a different body of case law that should apply when a prosecutor or another public servant commits a crime? Do you think that the analysis of what is a serious crime, reflecting adversely on the fitness to practice, do you think the threshold is lower when a prosecutor is involved?
I do. I do, Your Honor, Justice Nolan, because just to the point I was making earlier, that when assessing whether certain crimes committed by lawyers are serious crimes, one must look at the relevant surrounding circumstances. The case presented here is, in certain respects, unique.
You're specifically referring to abuse of authority, correct? More or less, all this comes under the ambit of abuse of authority. She attempted to use her authority to get leniency or a better result.
Yes, Justice Waples. Those are two of the most important aggravating surrounding circumstances. The fact that in trying to evade responsibility for her criminal conduct of DUI, she attempts to leverage her public position as state's attorney. It was almost as if State's Attorney Vekos was purporting to give Sergeant Neary legal advice and legal guidance on, well, do you know that you can use discretion to simply turn a blind eye to all this? So that is in my contention, that is a highly, highly aggravating circumstance directly related to the criminal conviction, that she's trying to evade citation and prosecution by leveraging her public position as state's attorney.
And then 1 week later, she then sent an email where she told the major primary law enforcement officers in the county that she was fearful of her safety. A week later, is that right? That she could not work with them, she thought or felt.
That was the implication. It sort of corroborates the threat she made in the processing room on the night of her arrest to Sergeant Neary, that, well, this is really going to damage my office and its relationship with law enforcement. And it was a direct allusion to the fact that she controls the Addison County State's Attorney's Office, and implying that she would use that authority to sort of retaliate or to try to get leniency for herself in a personal criminal matter. I should also note there are a couple other aggravating factors in my view that are directly linked to the criminal conviction. And that, number one, it's almost obvious, is that unlike many other attorneys who are convicted of crimes, State's Attorney Vekos committed her crime directly in the course of her work as a lawyer. She drove intoxicated to a work function, specifically the walkthrough of this potential crime scene, knowing that she was going to meet with law enforcement officers. Problem here was that after having that drink, or perhaps while finishing that drink, State's Attorney Vekos was apparently contacted by the state police and told, we need you to come back to this potential crime scene. And then she had a decision to make, and the decision she made reflects very, very poorly on her professional judgment. She chose to go herself, even though she knew and publicly volunteered in the press when she was running for her public office that any influence at all from alcohol or drugs in relation to driving is a crime. But we're now in a completely different situation where when State's Attorney Vekos stands up before a judge or a jury in a DUI case, the question has to be asked in light of her criminal conviction for DUI, can she command credibility and respect from the jury, from the judge, from her fellow attorneys, and from law enforcement? For example, if State's Attorney Vekos had been arrested on suspicion of DUI, and if she had said, well, I maintain my innocence, but I'm going to let the legal process take its course. I'm not going to try to improperly influence two different state police officers and say, well, you could let me go, or you could call a friend to drive me home. She could have decided to in no way allude to her official position and the office that she runs. If she had chosen differently, it's quite possible this petition would not be presented. As of today, State's Attorney Vekos is convicted of a crime. It's our contention it's a serious crime, and that triggers interim suspension under Rule 21. State's Attorney Vekos' decisions to drive that night reflect very poor professional judgment. The legal system, the legal profession, and the public at large rest on confidence that a criminal prosecutor will exercise good professional judgment in all cases.
My name is David Slay. I represent Addison County State's Attorney Eva Vekos. First time DWI, no accident, no injury, no property damage, no observed driving errata, does not constitute a serious crime. Even if it is a serious crime, if this court determines that the circumstances indicate that a sanction will not likely involve any interruption of Ms. Vekos' ability to practice. Every single case that Mr. Alexander cited that applied to prosecutors wound up with a public reprimand as the only sanction.
But wouldn't that be prejudging what the ultimate sanction is going to be in light of, the several aggravating circumstances that Mr. Alexander has pointed out?
Well, I want to get into that because I think one of the third part of my argument is that this particular request for interim suspension is both tardy and premature.
We're here because of the conviction.
We're here because she's alleged to have committed a serious crime with attendant conduct that is said to aggravate her criminal conduct. And she says something in effect, oh, come on, Ryan, can you just have somebody give me a ride home if you're concerned? That is not a full-throated demand for leniency.
Are you conceding that your client, as she was being processed, expressed concerns about the consequences of what was happening?
We have transcripts. I'm happy to send it to you. You can read the very words yourself. But she says something to the effect, this is going to be problematic. That's true.
And problematic in what sense? What did she mean? What did she mean by that?
There's any different ways to argue that. I don't have the transcript right in front of me. It's not a serious crime on its face. There should not be an interim suspension.
To say, I do think that this will ultimately, when a hearing panel looks at the totality of State's Attorney Vekos' professional misconduct, it will not give her a mere reprimand. It will be a suspension.